Swayam Prabha. Digital India. Educated India.
Dear students, in this class we are going to look into the interface between intellectual property law as well as the competition law, and what is this interface and whether there is a really conflict or whether it is supplementary or whether it is complementary, or what is the relationship between these two branches of law, that is the intellectual property and competition law, which we are looking into. So, the WIPO says that intellectual property allows consumers to make choices between competing entrepreneurs and goods and services they sell. Is really intellectual property allows, or whether the products, the innovative products which gives a choice between the products in the market or services between the market which they sell. So, there is whether there is an inherent pro-competitive effect of intellectual property in the market on intellectual property or intangible business assets, or whether intangible business assets have a direct correlation or connectivity with pro-competitive effects in the market. This we have to look into. So, it is said that without IP the market is going to be highly non-efficient. So, the efficient manufacturers and service providers are not going to innovate, they are not going to give very good services to, they are not going to be very good competitors unless intellectual property is not provided. To what extent this argument is correct? So, if there is an incentive to improve, there will be more number of products and more number of services which is available. So, if nobody is going to innovate in the market, the society is going to lose, and but whether an IP have a role of ensuring competition in the market. So, whether the intellectual property protection really differentiates between products, or whether the intellectual property protection really stops duplication or a free rider in the free ride in the market. This we have to look into. So, the WIPO says that too much IP is, so the IP is unduly extended, when it is unduly extended or to grant exclusivity over non differentiating features and to beyond certain limits, it become anti competitive. And when there is efficient enforcement means are not available, when genuinely differentiating features cannot be protected, then imitation or duplication follows and there is too little IP. So, too much IP is also is harmful to the market, too little IP is also harmful to the market. So, the WIPO studies which says that there must be a balance between these two. So, there must be the balance between the intellectual property protection and the competition law restrictions put on intellectual property protection. So, the objective of intellectual property protection is to induce the innovators, and ultimately they will provide better products for a better price, better quality and diversity of product and available to the consumers, and these are the considered to be. And what the competition law actually does? The competition law actually look into the market and which promotes competition, not the competitors. So, the competition law basically promotes the process of competition and ultimately promote the welfare. And competition policy set out the competition policy tools used by the state are for increasing or achieving allocative efficiency. The efficiency of the market decides the choice of products and also the availability of products and price. When competition is absent, there is no equilibrium in the market. So, there is no equilibrium in the market for prices, and the marginal cost also there is no equilibrium of the marginal cost as well. So, it ultimately leads to creates allocative inefficiency in the market, which is not good for the market, which is not good for the welfare of consumers. So, competition is always considered as an important source of productive efficiency, and productive efficiency which the firms produce the maximum output for a minimum input, that is the efficiency, that which shows the productive efficiency. And at the same time, the dynamic efficiency which occurs when the society takes full benefit out of the innovations that are economically viable. So, there is a connectivity between productive efficiency and dynamic efficiency. Is there the two products, the two concepts, intellectual property and competition, are contradictory, or whether these are complementary goals, whether these have supplementary goals, whether these have one and the same goal? This we are going to look into. So, some of them argue that there is an inherent conflict between intellectual property protection and competition law, and sometimes there must exist a trade off between competition, that for a short run allocative efficiency, and an innovation is always considered to be long run dynamic efficiency. And the IP, the intellectual property, always induces innovation by granting market power to the innovator for a limited period of time. At the same time, the competition policy's aim is to restrict the use of the market power. It restricts, and as earlier in the earlier classes which I said, that dominance of a firm is not per se anti-competitive. Dominance is allowed, but when they are when they start abusing the market power or abusing the dominant market power, then it is anti-competitive in nature, and the competition law has to step in. So, at least in some cases, when the intellectual property is started using its monopoly power to an oligopoly power, transition from monopoly to oligopoly is definitely going to be per se anti-competitive in nature. So, which always are going to contradictory in nature. So, see, in some places we can find a conflicting interest between these two concepts, but always these two concepts supplants or supplementary to each other or complementary to each other. So, if the firms or enterprises are under stronger competitive pressure, they innovate rapidly and come out with a product to the market first, because they have the pressure of innovation from their competitors. So, they have if there is a competitive pressure in the market, definitely it is going to be benefit, the market is going to benefit from that competitive pressure and come out with new innovations. So, the existence of more competitive rivals are going to reap more benefits to more intellectual property protection, and ultimately benefit to the market at large. And when some of the thinkers like Scherer and Rose in the 1990 study say that Schunter was right in asserting that perfect competition has no title to being established as a model of dynamic efficiency. So, the economists have different definitions of economic efficiency, but he says less cautious followers were wrong when they implied that powerful monopolies and tightly knit cartels had any stronger claim to the title. And what is needed for technical progress is a subtle blend of competition and monopoly, with more emphasis in general on the former than the later. They want to establish that when there is more and more technical progress, when the monopoly is curtailed with competition or the monopoly is regulated by competition. Thus, there will be more innovation in the market, at the same time there is more competition in the market. That is the ideal solution, which leads to the dynamic efficiency. So, the interface, so we can see that sometimes leads to the two distinct results, and the competition authorities to always look into these two branches, to what extent the intellectual property. Definitely every country for under the WTO agreement, 164 countries has to protect intellectual property under the TRIPS agreement. So, there is an obligation on each and every member to protect intellectual property. So, and remember the importance of intellectual property, the WTO agreement, the TRIPS agreement is that these 164 countries is around controls 99% of the world trade, and 99% of the world trade, which includes all these innovative so called innovative countries as well, those who export, only export the products. So, everybody should get intellectual property protection under every jurisdiction. So, if there is a trade off between intellectual property protection, if the standard of intellectual property protection is lower in some countries, it is directly going to affect the TRIPS agreement, directly is in violation of the TRIPS agreement, which is which the countries have problems under the WTO agreements, and the countries will take those countries providing less standard of intellectual property protection to the WTO dispute settlement system, which they have to pay for their violation of their commitments in WTO. So, we can see that most of the countries, the standard of protection of intellectual property is definitely the TRIPS agreement provides only minimum standards, not the maximum standards. It provides minimum standard. So, this minimum standard has to be provided by each and every country at the domestic level. At the same time, if you look into the competition law, there is no common standard other than some of the the popular OECD standards, OECD guidelines, which are made by some of the group of countries. So, there must be a balance of outcome between the intellectual property protection and the competition law. So, this is the jurisprudence, the immense jurisprudence which come out from the United States or from the European Union rather than from the developing countries. So, developing countries are very new to the interface between the intellectual property and the competition law, because they are very new in the sense that it is mandatory to implement the minimum standard of protection of intellectual property from 1995 onwards, and the developing countries got a 10 years of a transition period to implement the WTO obligations. So, by 2005 that particular period also was over. Only the exemption is given to the least developed countries. Now, all developing countries like India or Brazil has to fully comply with the TRIPS agreement, and they says we are complied with. So, there is a standard of intellectual property protection, and we have to look into to what extent the multinational companies or the patent holders or the holders of technology is exploiting the market, especially in developing countries. So, mostly this conflict not only comes in developing countries, but also in developed countries as well, because in a perfect competitive market, for example, like United States, the most of the intellectual property involved cases and competition law cases are between technology giants, and the technology giants are fighting each other to put their claim, or one company claims that the other company is exceeding the limits of the Sherman Act, exceeding the limits of competition provisions. So, the authorities have to decide, there must be certain standard of deciding these particular cases. Here we can see that the interface of intellectual property, see which he gives certain kind of exclusivity to the owner of the intellectual property. At the same time, the owner can decide to produce them himself, or he can give to he can license that particular rights to somebody for or excluding all others, always leading to a monopoly or even for a limited period of time. And and on the same scenario we can see that the lack of resources to produce, he may grant to another business or to another trader, he may license his technology to somebody else to produce in terms and conditions which is fixed by the patent owner, which may be restrictive in nature. If it is restrictive in nature, the authorities has to look into to what extent it is restrictive in nature, whether it is violating any competition law provisions. So, definitely there is a link between the intellectual property protection and the competition regulations in the market. So, this close link, which we can see that is characterized by two factors. On the one hand, the patents aims to prevent. So, we can very well see that the intellectual property is preventing copying or limitation of the patent goods to complement these competition policies or contribute to the fair market behavior. So, the objective is very clear that the intellectual property protection is supposed to contribute to the fair market. At the same time, if the monopolist is going to exploit the market, then the scenario is absolutely different. Then the competition law step in and which tries to limit the patent rights or the patent holder and barring him from abusing his rights, abusing or exceeding his rights. There the role of the competition law comes. So, in short, we can see that the too much protection, too high protection or too low protection, which is leading to trade distortions in the market. So, this is to be avoided. There cannot be trade distortions in a perfect market. If the market works when there is a harmonious relationship between intellectual property protection and competition law. So, this link, this interface and the interface in the sense that the protection of intellectual property or the monopoly granted by the intellectual property is harming consumer welfare, whether there is any kind of chilling effect on the innovation, which is discouraging further competition in the market or which is harmful to the consumer policies, then there is the role of the competition regulations comes. These concerns of which are in anti-competitive nature or blocking patents or we have patent ambush cases, there is standardization process and also we can see the violation of standard essential patents, the new concepts coming up. And what are the rules and regulations for the standard essential patents? We have enough jurisprudence from different jurisdictions, which we will see later. And there are anti-competitive practices or restrictive practices in licensing agreements, which we have to very closely look into the restrictive practices, which is put it in the licensing agreements. And we can always see that the effective competitions leads to an effective market performance and to a welfare market or a welfare society, which we can say there is a harmonious coexistence between the two branches of this law, that is the intellectual property protection and competition law. So, if you look into the objectives of these two laws or any law is the societal welfare, and it is always the interest of the society prevails, and to maintain that particular interest there must be competition and competition must prevail or the competitive process must prevail in the market. So, this it is said that this competition put lot of pressures on the innovators, on the product manufacturers and also the consumers respond to these innovations, and these innovations may reduce prices and which will be ultimately benefited by the consumers. And most importantly, the efficient allocation of resources is an important economic factor for economic welfare in any perfect market. So, in that case it is possible to better off without anyone making worse off. That is the economist says. So, if the society is better off, then the market is going to be perfectly all right. So, again the competition policy and competition laws have primary aim of their aim is to a perfect competition in the market and efficient functioning of the market, and the market mechanism works perfectly. And the market mechanism includes the price mechanism, the price systems, the pricing systems, distribution systems, and also this competition is always going to be a driving force of efficiency, the efficiency in the market and the market structure. So, the IPR is supposed to be control or regulate free riding in the market, and always the right balance between these two. So, the protection as well as regulation leads to the greater innovative products in the market and consumer welfare. So, there is more relevance of theory of the complementarity. The theory of complementarity have more relevance when it comes to the interface between intellectual property rights protection and competition law. So, we in the last class we talked about the private property owner. The private property owner have every right to sell it or license it to whatever he want to do, but when it comes to intangible property, he also have the similar rights, but the similar rights are always restricted or regulated by the competition law. So, certain regulations are put on his rights because mainly for the consumer welfare, and competition law. So, we saw the famous or we can say that the Adam Smith wealth of nation, what they argues for. His argument is very pertinent every time when we discuss this particular topic of intellectual property and competition. And he talked about the perfect market, he talked about the economics of competition law. He says the Adam Smith very clearly says the people of the same trade can meet each other, seldom meet even for a merriment or diversion, but the conversation ends in a conspiracy against the public or in some contrivance to raise prices. Then you have to control. You have to control against, you must have regulation against such conspiracies, you must have provisions against any kind of activities against public welfare, you must have provisions to control the enormous price rising. There the question of the competition law comes. See, the idea was very clear, the output of the firm better be able to take advantage to added productivity from specialized labor, and specialized labor in the form of innovation, and the sweat of the labor theory is also very much prevalent for the justification of intellectual property, as along with the famous incentive theory, the sweat of the labor. So, there is a specialized labor actually, but we can see that presently the firms allocate the market allocation, and some firms go for monopolization. Monopolization is not against any law, but it is necessary to put control or regulate the misuse of such misuse of the monopolization for the welfare of the society and welfare of the consumers. So, you require the tools of competition law in order to control the intellectual property protection. If we look into these the whole history of competition law, we can see some of the countries have competition law from the very beginning. So, if the United States come out with the antitrust law in 1890, so the Canada come out with the similar provisions in 1889 itself, and some of the countries much before. But the present evidences shows that means more than 120 countries have competition law presently in the world. It shows that the countries are more requires the help of competition law in order to curb the over exploitation of intellectual property rights. As I earlier I mentioned that more than 164 countries, 164 WTO member countries have intellectual property rights, but at least 120 countries have come out with competition provisions in order to curb these monopoly rights. And this objective, so you can see that the competition law, we already saw the objectives of intellectual property law. Here the objective is very clear, to protect the competitive process in the market, not the competitors. And the second objective which we can see is the economic efficiency. And thirdly, we can see it is the objective of the competition law to prevent the harmful effects of monopoly in the market, and ultimately secures the consumer benefits, ultimately the consumer welfare. That is the objective of the competition law. So, here you can see that, so the market power, so the competition law wants to control the market power derived from the application of intellectual property rights and abuse of intellectual property rights, and also curbing unreasonable conditions in licensing of intellectual property agreements. These are also the application of competition law to intellectual property rights. So, I can always say that there is no clash between competition law and intellectual property rights, rather than both are converging to the same objective. So, these are the two law tools to promote competition in the market, and competition law acts always against, they fight against the monopolies or exploitative practices of monopolies. And also you can see that these are two separate systems of rules applied to market based. For example, the competition perceived as two branches with specific objectives and work hand in hand to discipline the market, and the objective is primarily consumer welfare. There is no question of clash between the two branches of law in the case of consumer welfare. The ultimate objective is the convergence between these two branches of law. So, here we can also see that, so the IP licensing is always considered as one way of producing new products. The right owner has every right to license, but the question is whether he have the right to put unreasonable conditions. The answer is no. These conditions are subject to the market regulations. Market regulations are nothing but the competition law regulations. So, these conditions should not be unreasonable, and these conditions should not be unfair. These conditions cannot be against the consumer welfare. These conditions should not be against the market conditions, the market welfare. So, the competition law have an upper role to play in regulating intellectual property rights. So, and the technology holders can put lot of restrictions on technology restrictions, which may have ultimate effect of distortion in the market. So, there is a requirement of long term contract for long term contract with the technology licenses or the rival technology licenses, or financially unfeasible. So, that means you cannot put conditions in licensing agreement which is not financially unfeasible. Then non-compete clauses for an unreasonable period of time. So, that is also against the existing laws. Then geographical or territorial restrictions, then banning and preventing licensees from selling their products into certain geographical markets, which we discussed in the classes, the preliminary introductory classes on competition law. So, confining to the specific geographical areas also against the competition provisions. Then the unreasonable royalties are also considered to be anti-competitive in nature, or which is against the market. So, the royalty payments are also under the purview of the competition law, and other limitation of use clauses. So, limiting the use of patents or limiting the use of the technology to specific scientific field, and again license is allowed only in certain areas. For example, in the case of pharmaceutical, or it is medicinal, or it is confined to specific industrial areas or industrial products are unreasonable in nature. Then imposition of minimum retail price, minimum resale prices, retail prices, wholesale prices, and veto powers in case of future licenses. These are also has to be regulated with competition law. Then imposition of penalty clauses, where the patentee or patentee has to pay cost if it does business with another firm. All these provisions, which will we will deal with examples in the US jurisdiction in the coming classes, but these are considered to be restrictive provisions, which the competition law has to find some solutions. Then grant back clauses, grant by any kind of developments to the existing technology. The grant back clauses are sometimes become anti-competitive in nature. And then exclusive grant back clauses. So, exclusive grant back clauses, non-exclusive grant back clauses, and the right to use the patented improvements, and also exclusive tying and buying clauses, tying and arrangements or mandatory package licensing also is considered to be this anti-competitive in nature. But here you can see that the relationships, and we will see all the case laws later on, but we can see that the compulsory IP licensing provisions. So, there is antidote to the excessive use of monopoly rights. If it is oligopoly rights, the governments can always invoke the compulsory licensing provision, which is always look into as an antidote for the exploitative use or the abuse of the dominant positions. So, here we can see some of the examples where what happens compulsory licensing. So, the compulsory licensing is, as I already told, it is an antidote to the intellectual property protection. Once the intellectual property, the compulsory licensing is issued by the government against any one of the technologies, then the market is going to respond to that. So, the prices are going to be down, because the monopoly right is no more, it is a monopoly right, the monopoly right has gone. So, it is a compulsory licensing to any other people is possible. So, there is the perfect competition in the market is going to be balanced by the government through the compulsory IP licensing provisions. So, the government can always, the regulator can always play a very crucial role in controlling or regulating the intellectual property rights. So, if you look into some of the cases like the Microsoft case, which we will discuss in detail in the coming classes, these are the very famous cases. So, we can see that some of these technology giants try to exploit the market, the competition authorities are stepped in. So, the federal authorities are stepped in, and if you look into the response of these authorities in two markets, it is absolutely different. So, if you look into the Microsoft case in the US or in EU, in both the jurisdictions, the authorities are imposed heavy fines on these technology giant. But when it comes to India, the situation is different. So, one of the example is the recent case of Micromax, the Ericsson versus Micromax. So, the courts are very slow. The courts in India or the authorities in India are very slow to respond these kind of cases. Even though the similar situations in US and India, but the Indian courts are very reluctant to grant injunctions or very fast in granting injunctions and very slow in taking remedies. So, the remedies are no correlation with the developed countries. So, that is why I said in according to the jurisdiction and circumstances, the responses may be different. So, we already said that there is a common objective of these two branches of law, but there is different perspectives. So, these perspectives must be enhance the welfare, the societal welfare, and the IP may be used as a weapon to restrict competition between licensees given to the product. It should not be. The competition law should play a very crucial role in the anti-competitive behavior or the appropriation of intellectual property not in a correct way. Then again we can see that, so the IP law and competition law share the same economic objectives, that is the welfare of society, welfare of the market, then I would say that it is complementary. Both are aimed at encouraging innovation, industry and competition, and this innovation in the sense the intellectual property protection complements the research and development of every company, which ultimately leads to innovation and product verification, product specification and product choice. So, the product choices in the market. And antitrust or the competition law, which is always recognizes the critical role of IPR, and it is it tries to regulate anti-competitive practices of innovators or the monopolist. So, both these areas there must be common objectives, but they act differently. So, there is a freedom of every country to plan their competition acts based on their economic policies, but it should be in accordance with the modern practices. So, it must be for increasing the process of competition in the market. So, it must be for the efficient market performance, and it must be for the interest of consumers and economy in general. So, incentive theory of intellectual property, it works very well, and ultimately diversity of products, and which ultimately helps the market to find out more and more innovative products. So, we require intellectual property protection, at the same time we require the competition law in order to curb the activities of the monopolist. And the competition commissions all over the world usually always have a watch upon these oligopolistic activities or the monopolistic activities of the technology giants. So, usually everybody knows that IP creates monopoly even for a small period of time, and the competition battles monopoly, battles the monopoly to the extent within a framework. That framework, every country can make that particular framework for the enhancement of the economy or for the welfare of the consumers. So, I would say that there is no conflict of intellectual property protection and competition law, rather they are very complementary in nature, they are supplementary in nature, they serve the same purpose of the society, to enhancing innovation, it enhancing the welfare of the market, it enhancing competition process in the market. So, there is no conflict, rather they are supplementary and complementary in nature. In the next classes, we are specifically going to look into the US jurisdiction, the US antitrust law, and the practices, especially the immense jurisprudence which is emerged for more than centuries in the US jurisdiction. Thank you.